I would like to thank the editors of Diriti Comparati for their invitation to host a short presentation of my book, Freedom of Expression, The Revolutionary Roots of American and French Legal Thought, which came out recently with Cambridge University Press. What motivated me to write the book is the difference in the protection of freedom of expression in France and in the US. In the US, the legal protection of freedom of expression trumps the protection of other values. Social restrictions coming from civil society, political correctness, limit expression. By contrast, in France, limitations to freedom of expression are legitimate in order to protect other competing values. The role undertaken by civil society in the US is undertaken by the state in France. Civility norms are enforced by the state in France, whereas this is not the case in the US. So let me give you some examples. Hate speech is protected in the US, whereas it is not the case in France. The divergence is also obvious in the area of self-expression. Wearing conspicuous religious symbols is forbidden since 2005 in public schools and high schools in France. In 2010, the French parliament banned the wearing of the burqa, and another difference relates to political campaign funding. The United States Supreme Court has invalidated federal legislation imposing limits on independent expenditures, which usually come from corporations to support political campaigns, as a violation of their speech rights. France regulates strictly the funding of political campaigns and imposes upper ceilings to campaign expenditures. These differences reflect a different understanding in the role of the government in the determination of the content and the limits of freedom of expression, in my opinion. And this understanding on the role of the government was formed at the foundation of the two democracies in response to concrete political problems. Legislation limiting speech is frequently invalidated by the American Supreme Court. In France, similar legislation in many cases was not even referred to the Conseil Constitutionnel under the previous system of deferral to the Council, based on the initiative of members of the Parliament or the President of the Republic, but also most recently, since an appeals process was created to the Conseil Constitutionnel, legislation limiting speech is rarely invalidated. This indicates that the difference relates to the interplay between law and liberty in the two legal systems. The debates around the French Revolution, the Declaration of Independence in the US, and the construction of the federal government are instructive in relation to this interplay. So these debates, to a great extent, form the understanding of the proper relation between law and liberty in these two systems. Various interpretations have been proposed by scholars in the US on why this legal system protects speech so strictly. Some scholars discuss the emergence of a public consciousness for protecting free speech as having occurred after the end of the First World War. Others associate the emergence of the speech doctrine with the civil rights movement. Some others have most recently associated it with the class war and the compromise between various social and political actors that emerged in the 20th century around the New Deal. In this book, I complement those theories by arguing that the developments in the United States in the middle of the 20th century became possible due to a conception of the role of the government dominant during the founding era. So these theories proposed by other scholars do not assist our understanding of why, from a comparative perspective, the United States has arrived at protecting speech more rigidly than other democracies, which had to handle similar conflicts between political and social interests. It is a more profound tradition on the role of the government and a narrative about the meaning of liberty that the American Supreme Court expressed in the 1960s when it issued its important decisions protecting speech. When government intervention in the economy became acceptable in the US, the spirit of distrust towards the government during the founding era found expression in the protection of freedom of expression. The book discusses the progressive era scholars' ideas in the US on freedom of speech and shows that they won over to the extent that they resonated with the distrust towards the government dominant during the founding era in the US. The methodological approach followed in this book is based on Hans Georg Gadamer's theory of legal hermeneutics. Gadamer's thought is very helpful in this respect because he emphasizes that any interpretation as an actualizing appropriation of the meaning of a text or a phenomenon is founded upon an anticipation of meaning. Meaning is a dimension of existence. The interpreter projects various meanings onto the text that she is interpreting, formed by her situation in a specific context. Understanding Gadamer notes is an attitude which is not only reproductive, but also and always productive. The difference in the protection of free speech in the French legal system as compared to the American is the sign of a different common character, as Montesquieu defines this concept. A way of thinking which is the effect of a chain of infinite causes which multiply and combine themselves from century to century. It is an understanding on the role of the government that is reflected in the jury's opinions on favoring one liberty over another. It is the political imaginary which guides the ex-ante understanding of all jurists in a legal system concerning the necessity to protect one liberty to the detriment of another. Gadamer is also interesting because he provides important insights in relation to revolutions. Revolutions lead to a dialectic between the old and the new, he notes. Gadamer has noted that even when life changes suddenly, as it is the case during revolutionary periods, there is conserved under the prima facie change of everything a part of the past much more considerable than we think, and which finds its authority by allying itself with what is new. Some key ideas that I discuss in the book, because they help us make sense of this difference in the protection of freedom of expression, are the following. So first of all, what is at stake is a profound difference in the understanding of the role of the government on the imaginary level. In the United States, it is rarely legitimate for the government to intervene as the regulator of interpersonal respect for harm caused by speech. In France, on the contrary, it is legitimate. The understanding of the role of the government in France is affected by the organic vision that the Middle Ages inherited from Aristotle, from Baudin, and Rousseau's vision. In the French imaginary dominates an understanding for a strong government that has a positive impact upon society. And this conception was inherited by the nation during the French Revolution. Ideas of state paternalism, elaborated during the monarchy in France, persist in the contemporary understanding of the role of the government. So the differences in the fundamental presuppositions of the two legal orders can be understood, among other things, in relation to the different political problems which led to the two revolutions. Historians have shown that if the revolutionary impulsion in America was a reaction against the legislative activity of the British Parliament, one of the revolutionary impetuses in France was the problem of mass poverty. In the US, the revolution arose from a reaction against the activity of the English Parliament, seen as oppressive and as limiting liberty. The founding fathers implemented the separation of powers in a way that limits the government's impact upon individual liberty. The construction and the organization of the American states, as well as of the federal government, is characterized by a series of checks and balances, aiming to control, filter, and overall to moderate the power of the government and its impact on individual liberty. The judges are also operating in this general context. They think that it is less legitimate for themselves to intervene in defining the content and the limits of liberty. If French constitutionalism is founded on a positive conception and a trust regarding the exercise of collective power, the inverse attitude prevails in the American context. Another important concept, which is relevant to this discussion, is the concept of natural rights. Natural rights discourse emerged in the US, in America rather, shortly before the Declaration of Independence, in order to delegitimize attempts by the British Parliament to enact legislation limiting the negative liberties of the people in the colonies. In France, the debates among the participants in the National Assembly during the Revolution indicate that rights were seen as natural because society is seen as natural also, and as having the mission to help the citizens realize their rights. By society, the French revolutionaries mean political society. According to the dominant conception in France, liberty is to be perfected within society. Liberty makes sense only in society, which amplifies it and makes it meaningful through its laws. Similar philosophical discourse is absent from the debates related to the foundations of American constitutionalism. In America, a paternalistic conception of the role of the government did not prevail. And freedom of speech plays an important role in the system of government because it ensures accountability and transparency. If government is created in order to protect natural negative rights, freedom of speech is an exemplary negative right. In fact, it is an important liberty which ensures the protection of all other rights, serving as a check on government. It enhances the checks and balances of the American system of government. Another important concept which is relevant is the concept of republicanism. Both legal and political systems express republican ideals. In the US, the common good is defined as the need to protect negative liberties. The dominant conception is that the political sphere is instrumental to the private sphere. The private sphere is the sphere of happiness, and the public sphere is the medium to protect and preserve it. In France, negative liberties are protected only to the extent that they are compatible with the common good. The common good is something qualitatively different. The quality of being a citizen is primary, and the rights of man make sense only as rights of the citizen. The state has the mission to realize this universal conception of liberty for all citizens, conceived abstractly. So this leads to accepting a wide sphere of government intervention in defining the content and the limits of liberty, and in particular of freedom of speech. Contemporary law on freedom of expression in France and the US expresses these same values. Trust towards the state to moralize the citizens is dominant in France. Distrust towards the government to assume the same function is dominant in the US. The Burka Ban expresses this tradition. Hate speech regulation in France can be seen as protecting the targeted persons from harm and as protecting the citizenry more generally against the danger of reaching false opinions. The legal regime, which is protective of all these instances of expression in the US, reflects the understanding of minimal government that exists in Locke and Smith. The difference in the protection of freedom of expression between France and the US can be understood in reference to the understanding of liberty that is considered worth protecting in a legal system. Freedom of expression can be seen as a negative liberty, a liberty against the government, but it can also be seen as a positive liberty too, in the sense of having met the preconditions that are necessary to exercise this liberty. So in the US, freedom of expression is protected in the negative sense. In France, some of its positive aspects are protected as well. And this attitude relates to the legitimacy of the government to define the content and the limits of liberty. Even the protection of negative liberties requires positive action of the state. The state needs to make sure that itself and other parties do not infringe the negative sphere of inviolability of the citizen. But the protection of positive liberties requires something more. It requires more extended government intervention. It requires the state to engage in redistributing goods in order to make sure that the citizens will be able to exercise their negative liberties. The state should make sure that negative liberties do not remain empty forms, according to the famous Marxist critique. The state should help the citizens realize their liberty. In the area of freedom of expression, this means that the state intervenes, limiting the rights of some to enable others to be heard. This is relevant in political campaign funding. The rejection of limits upon independent expenditures during political campaigns by the American Supreme Court in Citizens United means that the court refuses to see the distinction between formal and real freedom of speech during political campaigns. The court overlooks that not everyone has the same ability to be heard. Similarly, restrictions upon hate speech in France are dictated by a comprehensive protectionist approach. The state intervenes to protect vulnerable groups from hate. It also intervenes to protect the creation of, to prevent the creation of stereotypes against social groups. These stereotypes mean in the long term that these groups are not heard when they speak. The Burka Ban in France can also be understood as part of a general effort of the state to make sure that the citizens enjoy real liberty. The ban was justified in reference to the need to protect women from the oppression of their families. It was also seen as a measure to help them realize their liberty against social pressure. It was seen as a measure that helps women liberate themselves as well. Their willingness to wear a burqa, when it was not formed under social pressure, was seen as part of a false consciousness. The state is invested with the task in France to realize the reason of the citizens because they are seen as incapable of realizing it themselves. As Habermas notes, the law extends between facts and norms. A part of the legal rules that we have is conditioned by our situation in a life world. Nevertheless, the law is also by definition a normative phenomenon. Thinking and writing about the law forces us to think critically about the ought, the normative element in the law. A comparative approach, like the one I engage in this book, aims to create a dialogue between legal systems in order to encourage critical reflection about the law. The US may be overprotecting freedom of speech in some respects, and France may be underprotecting the same freedom. Understanding the ideologies behind the emergence of a legal regime does not mean accepting historical determinism. It is possible to think critically about just criteria for limiting speech. Principles and rules elaborated in the past to meet concrete sociopolitical needs may not be relevant today in order to address contemporary concerns related to rights. So the book engages towards the end with contemporary debates on hate speech, the protection of privacy, headscarf bans, and political campaign funding, and proposes criteria for government intervention in order to limit expression or not in these cases. The reason of the citizens is to be trusted in cases that relate religious expression. In the area of hate speech, government intervention is legitimate in order to limit it when an individualized target is at stake. In relation to political campaign funding, it is legitimate for the government to intervene in order to affect social power imbalances. Contra Citizens United, a conception of the marketplace of ideas as a sphere of absolute freedom, overlooks social power dynamics. The book argues that it is legitimate for the government to intervene in order to overcome the distinction between formal freedom and real freedom of speech for some participants in the political debate. Thank you again for the invitation, and I hope you find the book interesting.